Good morning, everybody. Happy Tuesday. Somehow it is July 1st. Somebody's going to have to explain to me how that happened. Feel free to do so in the chat, but welcome to the Courtroom Files Live. Let's start with Judge Middleton, where a little earlier this morning he was addressing somebody who was in custody.
Mr. Josh Robert, the Chief Assistant Prosecuting Attorney, is here as well. You got arrested last night for failing to appear for a probation violation arraignment. Where did you get arrested?
My mom's.
In Michigan Avenue?
Yes, sir.
They came specifically to get you?
He pulled up. I was working on my wife's car, and I pulled out, and then I turned around right by him. He was parked on the side of the road. I turned around right there and pulled back in, and I showed him the oil where it was leaking, and I was trying to fix the car. I was going to appear. I tried to get a hold of Miss Davis about my kids. I just found out I had two kids, and one's racist, and the other one is mixed, and I got caught in between the two of them.
All right. Well, Mr. Bush was your lawyer on this, and your probation officer was Autumn. So let's talk about this. You've been off the radar. You've had a rough couple of years. If we go way back.
Sorry, I didn't even know I had.
Resisting and obstructing and domestic assault. 2020, assault with a dangerous weapon, 3 counts, and resisting, obstructing. And then this count started, hold on. Started as assault with intent to do great bodily harm, domestic violence, second offense, 3 counts. You entered a plea to domestic violence, second. 2 counts, and I put you on probation. I gave you 62 days and deferred 60 back to last May. And then you went off the grid. So I did a bench warrant for you last October. I haven't seen you since. Let me talk about the actual petition. I'd like to ask you a bunch of questions, but your lawyer isn't here. You were struggling with methamphetamine. You were connected to CMH, and then we just lost track of you. The allegation is that you failed to abstain from the use of drugs and alcohol, and then failed to appear for your probation violation in October. I have 60 days of jail hanging over your head, which is likely to be imposed with your issues. I don't know where you've been. You've been just hanging around waiting to get arrested, I guess. But at least the good news is you won't have to look over your shoulder for a warrant anymore. I'm going to show a plea of not guilty. Appoint an attorney, set a PV hearing. You have a history of assaultive behavior, and you didn't show up, and you just been under the radar.
And that rage baiting, they set me up for that domestic. That was wrong. I got a detective on this that's working on this from the FBI. I'm serious. I'm not playing with this no more. I didn't even know I had kids. These guys are really wrong doing this to me.
Well, you did this to yourself. You just quit showing up. You quit going to your treatment. You quit reporting to your probation officer, and you just got arrested. So like I said, we're going to resolve this. But I'm sorry, go ahead.
I'm still doing my treatment. I didn't know I had kids, Your Honor. I know that's no excuse. I should have still came in. I had no clue.
Didn't know you had kids.
Yeah, I got kids. I had no clue I had. They got into a fight. I tried to break it up. I got one kid that's racist and I got one kid that's mixed. I didn't even know I had.
All right, well, that's no reason to not show up for 8 months. So we'll get it back on track. Your bond's canceled. You're gonna sit there until we resolve this. Mr. Bush or another attorney will be represented to you. I'll let Autumn know you got picked up. Sounds like you're having either some mental health issues or a meth crash or both. So
No, I got my toes rotten. My toes rotting. I need to get my toe looked at. I gotta get to a hospital. It's the woman said it looked like gangrene. You can see the bone. It's bad.
all right, we'll have the jail nurse take a look at that. We'll get at this sooner rather than later because I'm gonna be leaving on vacation and I don't want to make you wait for several weeks. So it'll probably be sometime next week. All right, sir. Well, Keith, thank you. That's something we won't have to do this afternoon. He doesn't look like he's doing real well.
Could you give us the name of the FBI agent he's speaking to? Might be.
I think his name was Reggie King. I think Reggie's still with the FBI, I believe.
All right, that's a good way to start the morning. Missing toes, the FBI, and a bunch of children he didn't know about. Good morning once again. Welcome to the Courtroom Files Live, where you never know what you're going to get. Let's go to Florida. Wade Mercer is doing first appearance.
Thank you. Ladies and gentlemen, in the jail, there are two attorneys involved in the first appearance process. I want to make sure you can see and hear both of them. I know that you can see and hear Mr. John McDaniel, Assistant Public Defender at the jail. I'm going to ask Mr. Mitchell in the courtroom to introduce himself.
Jake Mitchell on behalf of the state.
Video and audio working good today, Corporal?
Yes, Your Honor.
Great. First case is Sophia Nazarchuk. Nazarchuk, good morning. Ms. Nazarchuk, you're here because you have allegedly failed to appear at a truancy court date. Judge Garcia issued a hold without bond warrant, ma'am, so we could get you the first appearance. What we did this morning is I sent word down to her office to see what she wanted done with this case, Ms. Nazarchuk, and she's asked that you be given a notice to appear on August 13th at 3:00 p.m. I'm going to ask the jail to give you a notice to appear to be in court August 13th at 3:00 p.m. Now, Ms. Nazarchuk, if you don't show up on that day, what's likely going to happen is you're going to have another warrant issued, and at that time you would not get out the next morning. So it's very important that you be in court August 13th at 3:00 p.m. Do you have any questions, ma'am?
No.
All right, have a good day, ma'am. Derek Bryant. Mr. Bryant, good morning, Mr. Bryant. You're here because when you got booked yesterday on the Jackson County charge, it appears Gadsden County has a warrant for you. So, Mr. Bryant, what that means is you're going to be held for Gadsden County. I do not see a bond on this warrant.
Yes, sir.
Corporal, is that what you've got? Do you see a bond on the warrant, Mr. McDaniel?
No bond.
So, Mr. Bryant, what that means is you're going to be held until you can get over to Gadsden County. What usually happens is when you get near the completion of your sentence here, when you get down to having a few days left, they'll go ahead and notify Gadsden County to come and get you. And Gadsden County will pick you up. You may or you may not get a bond once you get back there to Gadsden County, but right now you've got no bond from that warrant. Any questions, sir?
No, sir.
Have a good day, sir. Henry Lee Ward. Mr. Ward, good morning. Mr. Ward, you're here for first appearance accused of one count of domestic battery. Mr. Ward, there is probable cause for the charge in the complaint. Mr. McDaniel and Mr. Mitchell, the alleged victim, sent an email this morning to my judicial assistant. Basically, it said, well, I'll tell you what it says. It says, my children's father, Henry Ward, was arrested for battery and should appear before you today. The neighbors called the police, but there wasn't any physical contact. It was a heated argument. I did not wish to press charges. I'm emailing because I have epilepsy and I can't be home alone with our small children, and my mother took us to Alabama to her home. Thank you for taking time to read this email. And supposedly that email is from the alleged victim. I have no idea. Mr. Ward, that version of what she's saying now is not what she told law enforcement last night or yesterday, according to the complaint. And according to the complaint, she did have injuries yesterday, which it's hard to explain in a verbal confrontation. So there still is probable cause. Your criminal history is not good. You're going to get a bond this morning. I know that you got out of prison last year, but I think you're entitled to a bond. Let me see if the state or defense have any additional information before I determine what bond is set. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
Nothing, Your Honor.
Mr. Ward, your bond's going to be $3,500 cash or surety. Your bond has a condition of no contact with the alleged victim at all, regardless of whether she wants contact or not. At this point, at least on a temporary basis, there's no contact with her at all, but you do have the right to use the phone to contact friends or family or a bondsman, and you do have the right to go through a bondsman and pay a percentage of the bond instead of paying the whole amount. But your criminal history is hurting you at this point. Mr. Ward, you'll get to use the phone in just a few minutes. Do you have any questions?
No, sir.
All right, sir. I wish you the best. Roy Swindle or Swindell?
Sir.
Mr. Swindell, I've got your name spelled a couple different ways, and whenever that happens, I always try to make sure which one is correct. So when you're booked, it was Swindell, and now they've
Yes, sir.
got on the jail sheet Swindle, which is correct.
The first one.
Okay. So
LL.
Corporal, if y'all can make sure all your jail records match, please. The jail sheet is incorrect. So, Mr. Swindell, the reason you were brought back is Mr. Mitchell or someone had allegations that there had been contact inappropriately. Was that the state had the allegations, or where did that come from? You know?
It was his mother, I think, or something.
Someone was in the courtroom that day.
Yes, and she told me while we were here in the courtroom.
So the jail has produced a sheet which seems to imply that there may have been contact with the alleged victim after you were ordered to have no contact. Corporal Drown, is that correct?
Yes, Your Honor.
So there's some evidence that may have occurred. Mr. Mitchell, what is the state's position on telephone contact at this point and or revoking a bond, at least until we can have a hearing?
I think as it stands right now, he's in clear violation of his bond conditions in the new law. So we just request that his bond be revoked in that for violating the conditions. And as for his telephone privileges, we'll leave that up to the court.
Mr. McDaniel?
Yeah, I don't even know what, I have no idea what any of this is even about, so I guess, when you say that, I mean, I don't even know what the contact was or who the contact was with, how it was made.
Corporal, do you have any additional information you can give to Mr. McDaniel that you may be familiar with from y'all's review of the phone records and conversations?
Just the phone records themselves is what I was able to have Miss Mercer pull up. So she tried to come visit him physically, but Sergeant Kent turned her away because we knew there was a no contact.
We just asked the
Okay.
court, maybe remind her that he's not supposed to have no contact with her. I mean, it sounded like she come up here, but that's.
Yeah,
Y'all-
so I'm not going to, that's not a violation for him if she tried to come, if he didn't actually see her. But Corporal, did someone listen to the phone conversations?
I'm not sure, Your Honor. Ms. Mercer just printed it up and told me that he had contact. I don't have access to the phone calls myself.
How do we know he had contact with her if no one listened to the conversations? How do y'all know who was on the other end of the call?
I can go contact Ms. Mercer. She'll be able to tell me because her and Chief and all them listen to the phone calls when they first get here.
Yeah, we need to know that because that's the whole reason he came back today, Corporal. If you can check with them, if someone says they listen to the phone calls and they have reason to believe it's her, that's one thing. A piece of paper saying, I don't know what this piece of paper says. It just says there's some calls made. I don't know how you determine from this piece of paper who was on the other end of the line.
There's a final page that shows the victim's name, but I think that's just showing that the call was blocked at the end or something.
I think someone listened to the phone calls. They just didn't
Yeah.
get that information to Corporal Drown.
I'm not going to say that out loud.
So, Mr. Swindell, give us a second. We're going to try to get a little more information before I can figure out what to do. Stacy, can you ask Pamela, because I'll forget, can you ask Pamela to forward that email to the state in defense, please, so they can take whatever action they think is appropriate. Yeah, that email from that person. Mr. McDaniel, while we're waiting on that, why don't we go ahead and bring up Mr. Funderburk from yesterday? Mr. Funderburk, come on up, please. Mr. Swindell, if you'll just step back, we'll call you back up in just a second, sir. Mr. Funderburk is here from yesterday's case 25-277 CT. This is the state of Florida. Get my mouse to work here. Versus Alan Funderburk, and that Mr. Funderburk had court yesterday. I think he had some issues and called us well before court started to say he was going to be late. And I said, rather than driving 2 hours to be late, when he got here, we may have already been through with court. That's why I said, just come tomorrow morning. I think that's what my judicial assistant told you. So he has shown up tomorrow morning. Mr. Funderburk, you're accused of one count of no motor vehicle registration. I'm going to appoint the public defender's officer to represent you. I'm going to ask you to listen to Mr. McDaniel, and he's going to kind of tell me where we stand in your case. Mr. McDaniel.
Your Honor, we're going to take care of it this morning. You know, Jake, this is for Jake. He was, you know, he's got a boat. The boat's registered, and you know, he used a borrowed trailer from one of his friends to put the boat on to go test it or whatever. You know, so the trailer did not. It's not a motorized vehicle. It's a trailer. Yeah, I didn't know the state might be inclined to change that to a civil infraction.
Hang on just a second.
The citation does say boat trailer not registered.
That's what I was double checking. I would have no objection to doing something similar like we did with Travis Purdue yesterday.
What did remind me? What charge? What citation did we pick? Did you pick? Failure to display tag. Okay. So Mr. Funderburk, if Mr. Mitchell agrees to transfer this to civil citation, it takes it out of criminal court and puts it in civil court. It's still a ticket, but it's a civil ticket, like a speed ticket. It's not a criminal charge, and it carries a fine of 163. We had one yesterday. It was 163.
What was that, 163?
We did one that was 163
We were
because I thought it was
equating that.
113, and y'all told me I was wrong. That was a different
That's right.
citation. So this one is how much? $113 is what it would be if you wish to plead no contest to that civil infraction, and you would have 60 days to pay.
I'll pay it this afternoon, or right after now, Your Honor.
So the plea of no contest is what you
Yes,
want
sir.
to do.
Yes,
So we'll show a plea of no contest to the amended citation for
Display no tag or registration.
fail to display no tag,
Yeah, fail to display tag or registration.
fail to display tag or registration, $113 within 60 days. And
$113, yes.
we're going to give you some paperwork, Mr. Funderburk, and that'll take care of this case. So Mr. Mitchell's trying to help you out by transferring it
All
to
right.
civil infraction. Let me sign this. We'll give you a copy of it. Do you have any questions?
No, sir.
We did not issue a warrant for him because of his phone call, right?
No.
All right, Mr. Funderburk, give you a copy of that. There was no civil citations that he was issued simultaneously, was there? That would be on
No,
the
Your Honor.
docket itself.
There was not any.
Do you need that on the civil infraction? Okay, thank you. Mr. Funderburk, we're going to give you a copy of this disposition. You can pay it if you wish to pay it the day downstairs. You don't have to. You have 60 days to pay. But if you want to pay it before you leave the courthouse, then Deputy Spates in the back can show you where to pay that at. Okay.
Thank you, sir.
Have a good day.
You as well.
All right, so is the corporal back in the room yet, Mr. McDaniel?
No, Your Honor. Judge, I mean, he's being held without bond on a violation of state probation, so, I mean, he's not
Yeah,
going nowhere.
So
The bond issue is not as important to me as the continuing contact, because the system at the jail can be manipulated very easily. I have found, to my dismay, but I don't have any control over what system they choose to use out there. It's pretty easy to call somebody else and then use a third-party calling system to call an alleged victim. So I'm going to stop all phone calls if, at least temporarily, if there's credible evidence that he's violated my court order, but I'm not going to do it without some evidence, obviously. Mr. Mitchell, you're about to say something?
Yes, Your Honor. Ms. Jackson, who's watching with us right now, she has access to secure. Someone was able to pull him up on there. She says that on June 25th, there were 2 phone calls of them talking on the phone. And on June 24th, there were 5 calls right now. And she said that the account that was registered on those phone calls was registered as Elizabeth Emons.
Who is Miss Jackson?
Stephanie.
Okay,
Stephanie
okay.
Stewart.
Miss Stewart. Okay,
Yes.
she's married to, she's a Jackson.
Yes.
now. Okay, I've got you. So, Mr. McDaniel, anything else you want to be heard on? Let me tell you my intent first. My intent would be to temporarily stop all contact other than contact with an attorney until we could have a more detailed hearing. So that way you would talk to your client afterwards. And if he wants to have a hearing, we certainly can do that and let the jail bring their witnesses or the state attorney's office bring witnesses to actually testify how they know it's the alleged victim. But in the meantime, I probably would be inclined to stop all telephone contact until we had that hearing. Mr. McDaniel, any input on that?
Judge, I mean, I think the jail enforces their own rules, and I mean, they've already stopped all telephone contact, because he's violated their rules. So I don't know when he'll get them back, but
No one's told me that.
with the jail,
So
they have their
Sergeant
own
Gross,
rules. So, yeah.
Corporal Sergeant Gross, Mr. McDaniel thinks that the jail has already stopped all telephone contact for Mr. Swindell. Is that accurate?
Yes, sir.
He has no telephone contact at all then?
Not right now, no, sir.
Okay. Is that indefinite?
Oh, well, I mean, that's, if you, at some point say he can have phone privileges, then we can,
What's the time frame you gonna do? Like 30 or 60 days, or how long do y'all normally do?
Well, I think right now, I don't think they have intentions of until you tell us any different.
What I want to do is I want to order no telephone contact at all temporarily, with the exception of with an attorney. And Mr. McDaniel, if Mr. Swindell would like a hearing on that, that's perfectly okay. We can have it next few days. But there appears to be credible evidence that he's violated a condition of my bond. I'm also going to change that bond from the previously set bond of $5,000 to no bond. As you said, Mr. McDaniel, that really doesn't change a whole lot because they already had no bond in the VOP. So Mr. Swindell, you can communicate with your attorney, but there's evidence you have contacted someone after I ordered you not to, or maybe they contacted you. I'm really not sure, but there are multiple conversations, it appears, which is potentially a violation of the bond. So Mr. McDaniel, anything else that we have on that case?
Yeah, we would just ask, Your Honor, maybe that he had to be able to have contact with his mother, and if he violates that, then obviously, if he does something that he shouldn't be doing, but he does have a more serious charge, and, I hate to have someone that says no contact with anybody on the outside.
His mother was.
Yeah, I have no problem with him having contact with his mother in person, but I do not trust the jail system to not be manipulated, so that request will be denied. Mr. Swindell, he's still in the room, correct? I'm assuming Mr. Swindell can hear all this. Mr. Swindell, I wish you the best. We'll see you at your next court date, and talk to Mr. McDaniel in more detail if you'd like a more in-depth hearing to show the bond violation. Just making a preliminary finding at this time. Mr. McDaniel, it's everything I have on my first appearance list. Anything else from the public defender's office?
No, Your Honor.
And Corporal Drown, anything else from the jail?
No, Your Honor, that's it.
All right, that is that for first appearance in front of Judge Mercer. Let's go to Texas, and we'll say good morning to Judge West because she's the best. However, she's muted. Why do you do me like that, Judge? Let's do this. Let's go to Van Zant County, Texas. We'll stay in Texas.
Daniel or 7.
Well, Judge gets her audio sorted. But this is Judge Chris Martin. This is a judge we have not seen before, at least on this channel, so let's check it out.
Daniel, but I've only been hired for about a week, and so I would like another pretrial on Mr. Daniel.
Say that again. We show that Mr. Eisenberg was retained on Mr.
He still is. There hasn't been a motion to substitute. I've been hired. I may leave him on it with me or not, if that pleases the court, but I would like another pretrial so I can do a little better assessment of it. I've just been on it just over 1 week.
Say,
I-
no objection, Your Honor. All right, there being no objection, court will reset. Mr. Daniel for pretrial. Mr. Wells, I've got August 12th or 14th.
Let me look. August 14th is fine, Judge.
August 14th. All right, Mr. Daniel, you ordered back for pretrial August 14th at 9 a.m. Once you sign your notice of setting, you're free to go.
You can wait down the hall. And Judge, the second one is Patricia Avizo.
Ms. Arvizo,
And this is the one I'm appearing for, Mr. Eisenberg.
just cut across. There you go. I don't think about it. All right, this is cause number CR 25-91, State versus Patricia Lopez Arvizo, set for pretrial. Okay, Mr. Wills, you said you are standing in for Mr. Eisenberg on this one.
Yes, Judge, and they're working on resolving that. If it's acceptable, you can do a pretrial or you can put it on docket call. Either one. He has no motions to file.
Okay, there being no contested pretrial motions on file, court sets this matter for docket called August 12th or 14th, Mr. Wills.
Let's do the 14th if that pleases you.
Court sets Ms. Arvizo for docket call August 14th at 9 a.m. Ms. Arvizo, have you signed your conditions of pretrial release yet? Have you met with Mr. West? You have, Mr. West, you met with her? Okay. All right, then, Mr. Wells, once she signs her notice of setting, she's free to go.
Thank you, Judge.
Good morning, Mr. Harrison.
Morning, Judge.
This is cause number CR 24-225, State of Texas versus Shiloh Darnell Scott, and we're set for a docket call. Go ahead, Mr. Harrison.
Your Honor, we have a discovery, we have an offer, we just need a trial date.
All right, and can you go ahead and place on the record what the offer is, either state or defense, what the offer is, what's being predicted, and so that I can know that Ms. Scott understands that the court may not allow her to engage in plea negotiations after today.
Judge, my recollection is it was a 10-year TDC offer.
Is that correct, state?
Best I can tell, Your Honor, Ms. Curry has actually been dealing and speaking with Mr. Harrison.
All right, court will set Ms. Scott for jury selection beginning August 4th. Ms. Scott, when you report to the court on August 4th, you will not report to the courtroom. We'll be bringing in a jury that day. Your case will not be set for trial because there's other individuals ahead of you. So you'll report downstairs and my staff will be down there to meet with you along with the pretrial release officer to give you a notice of setting and reset you.
Your Honor, can I have 1 second?
Yes. And you're not required to be here on the 4th, Mr. Harrison. You're not required to be here because she's being placed on the rolling trial docket. And I don't anticipate she's going to go to trial.
I see. So that's not our actual trial date.
That's not your actual trial date. If there's a request for a special setting, we can talk about that. But right now, I would just place her on the rolling trial docket, and she would be on that until her case reaches the top 10, and then which you would be notified that you're potentially going to trial.
Could we approach trial?
Yes. All right, there being a request for a special setting in this matter, the court sets Ms. Scott for trial on March 16th. Mr. Harrison, I do need Ms. Scott though to report monthly. So what I'm going to do is I'm still going to have her come in on August 4th, and she can check in with staff to receive pretrial release services with Mr. West, check in with court staff, and then, but we'll especially set it in March.
All right. Should I put March 16th special setting on our reset notice?
You can. Ms. Scott and Mr. Harrison, I should have a note that she's delinquent $80 on her pretrial release fees. That's something that you're aware of.
I thought it was good. I can pay for it after.
All right, what I want you to do is go to the pretrial release office, check with them, and any delinquencies you have, get those paid for. All right, you're free to go.
Thank you, Judge.
Thank you, Mr. Harrison. Mr. Harrison, if you'll wait for just a moment. Mr. Bratton, is it?
Yes, it is, Judge.
All right, Mr. McKeever. This is cause number CR 25-81, State versus Gary Ray Van McKeever, and we're set for pretrial. Go ahead, Mr. Bratton.
Your Honor, we're requesting a reset of the pretrial. I've talked to the prosecutor. There's some discovery needs to be completed on this. This is our first appearance after arraignment.
What's the discovery issues?
Your Honor, my understanding is that he has not had access to the CAC interview, and so he would need to be provided with a link, since that's not something that we could place on the portal. I've already explained that process to Mr. Bratton, and we'll make sure that that gets done.
All right, and Mr. Bratton, if I reset you for August 12th or 14th?
14th, if we could,
14th?
Judge. Yes, sir.
All right, and you'll be able to, should be able to review the CAC video before then. Court sets Mr. McKeever then for pretrial August 14th at 9 a.m. And once Mr. McKeever signs his notice of setting, he's free to go.
I've got that here.
Thanks, sir.
Okay, well, not the worst place we've ever been. Not the most exciting, but not the worst either. You know, I didn't know that the Coldplay guy was also a judge, so that's cool. It's a cool looking courtroom for sure, and seems like they're on their game there. Fairly procedural, fairly on point with things. Not as chaotic as some, so that's nice. Let's switch it up though. We'll go to Fulton County, Georgia, where they're doing their all-purpose calendar. Spend a little time there.
That he had a PI case in 2016 and a peeping Tom in 1991. He does have a lengthy criminal history. Give me just 1 second. I got all the cases this morning. So I'll pull it right up for you. Okay.
I have it, Your Honor. There are 74 arrest cycles in Georgia. The last arrest appeared to be from March of this year for felony theft by shoplifting. That case appeared to be dismissed. There was a 2024 burglary out of Fulton County. There was an FTA from 2021. There was also a burglary in 2018 out of Fulton County. There was a 2017 misdemeanor conviction for criminal trespass. There were 3 separate ones for criminal trespass in 2017. There's also a 2006 felony conviction for a burglary. A theft by taking felony conviction from 2005. Another burglary also from 2005. Arrest and convictions for theft by taking in 2004. a felony conviction in 2003 for possession of a controlled substance. Also in 2001, there was a felony conviction for entering auto and theft by receiving stolen property.
Okay, thank you. Thank you, Ms. Washington. I appreciate it.
You're welcome.
Yes, Ms. Harrison.
Yes, Your Honor. This incident occurred on June 14th. The place of the occurrence was Washington Road, the actual parking lot of 3887 Washington Road in East Point, Georgia. Officers were advised and called to the scene due to a female driving by southbound on Washington Road. She informed officers on the call that she observed the defendant on the side of the road waving his penis. And officers, she pointed him out, and officers were able to go to the location and find the defendant. He was sitting across from the victim at the time, Miss Malia Gaither. And officers asked her what occurred, and she informed officers that she was sitting at the bus stop across from the defendant, and she didn't do anything, and he was waving his penis in the air. And she believed he did it on purpose and was making noise to her to get her attention so she would look at him. And he was holding it in his hand. And like I said, Your Honor, the state he did have prior similar cases like this, the 2016 PI case. And as such, the state's recommendation, Your Honor, is, I'm sorry, one second, I lost my place. Where did it go? The state's recommendation in this case is 12 months served 90 days, 15 days credit for time served. The defendant has been incarcerated since June 17th, balance probated. We're asking for SDET, 40 hours of community service, no further contact with Malia Gaither. And the defendant also has another case. It is SG 73124124. For that case, the state's recommendation is a 12-month probation concurrent with this case. Stay away from Chevron, located at 4485 Washington Road in East Point, Georgia. And that'll be all for the state. We ask that the defendant stipulate to venue purposes and ID.
What is the charge for the add-on case?
It is a criminal trespass.
Yes, Your Honor, and the case number is 25 CR 003-645 F is in Frank, criminal trespass.
Thank you, Ms. Young.
You're
Thank
welcome.
you.
Whenever you're ready, Mr. Masajigan.
Thank you, Your Honor. As Your Honor alluded to before, the only real quibble we have with the state's offer is that we asked for Mr. Ross to be given 30 days to serve and 15 days credit for time served so that he'll be released as long as there's nothing else holding him within the next 24 hours. We understand he has a significant amount of cycles, but these are pretty much all related to, by what I could hear, crimes of poverty. As far as PI cases, the state mentioned one case from 9 years ago, another one from over 30 years ago. Your Honor, we just feel that the jail time is excessive given that Mr. Ross has already done 15 days at this point. So we would just ask, Your Honor, that the jail time be reduced and all other conditions remain the same.
Okay, I'll need some background on Mr. Ross. I'll need to know if he needs services from a social worker. Does he have a place to stay? Things of that nature. Does he have a job? Is it going to be difficult for him to accomplish what the state is asking? I don't want to set him up for failure.
Yes, Judge. Mr. Ross does have family in the area that he was previously staying with his niece. He also has his father who's local here in the city. He receives a Social Security check every month for his income. So he does have a place to stay. He does have not employment, but he has income. Your Honor, we believe that he will be able to land on his feet once he's released.
Okay, I'm not sure, if keeping him in custody, it would be the solution, but I do think that there needs to be, along with the SDET, a mental health evaluation. So I would order a mental health evaluation along with the SDET. You're telling me that he does have a place to go, and that he does have some type of income. So I'm going to keep him on probation for the entire 12 months. But I would require him to do MHET as well. Do you need to discuss that with him?
Yes, Your Honor, just for 1 minute. Thank you, Judge. Thank you, Judge. Mr. Ross is going to plead guilty under those conditions.
Okay. And Ms. Harrison, that Washington Road address, was there a specific business that he was in front of, or was it the roadside? Where was that?
Give me just 1 second, Your Honor. Yeah, it's the Chevron located at 4485 Washington Road. So Chevron
Okay.
service station.
So for both cases, it's the Chevron, the same Chevron?
The public indecency was at a bus stop in a parking lot. So I'm guessing they're all pretty close.
If there's a location that you want him to stay away from for the PI, I'm happy to order that.
Okay, the location would be the parking lot at 3887 Washington Road.
3887, okay.
Okay, thank you.
If nothing further, Mr. Ross, it's my understanding that in case 25 CR 0034002Y, you wish to plead guilty to public indecency. And in case 25 CR 003645F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. Yes, sir. Yes, sir. I don't put the S. I only answer. Yes, sir. I'm gonna answer. So I be on probation. I get on probation.
Okay, yes, Mr. Ross, you will be on probation.
No, I believe you get on probation. 12 months.
Yeah. Yes, sir. If you go through with the plea, part of the plea arrangement is that you're going to be on probation for 12 months, okay?
Okay, yes, sir, yes, sir, yes, sir.
Okay. So do you wish to plead guilty to this public indecency and criminal trespass to those charges?
Yes, sir, yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning, Mr. Ross?
No, sir. No, sir.
You've been represented by Mr. Massageddin there. Are you happy with what he's done for you?
Yes, sir, yes, sir, yes, sir. So I'll do that tonight.
He'll let you know when you'll be getting out, okay? So, you understand?
I do that tonight.
You understand? Okay, you'll be getting that. If you don't have anything holding you, Mr. Ross, you'll be getting out as soon as the jail can process you out, okay?
Oh, yeah. Hey, net,
Okay. Well, if that's okay, that's the case, Mr. Ross, then you'll be getting out as soon as they can process you out, okay? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty, you're giving up that right?
Yes, sir. Yes, sir.
Has anyone forced you to plead guilty?
No, sir. No, sir. No, sir.
Okay. I'll accept your plea, Mr. Ross. For the PI, the court sentence is going to be 12 months to serve 30 days, credit for time served 15 days, the balance probated. An SDET and MHET 40 hours of community service, and no further contact with Ms. Gatier. For the criminal trespass, will be 12 months concurrent, and to stay away from the Chevron at 4485 Washington Road. Also for the PI, you to stay away from that bus stop that's on Washington Road as well. So you can't go back to that Chevron, and you can't go back to that bus stop. You understand me, Mr. Ross? If you need to talk to him, Mr. Misogyn, I can't hear him because they have him muted, so if you need to answer a question for him, or I'm happy to speak with him if need be.
Thank you.
Okay, all right, and so, Mr. Ross, I understand your situation. While you're on probation, I'm gonna waive those fees, okay? So all you have to worry about is reporting, make sure that you report, and make sure that you get this, the terms of the probation done, okay?
Yes, sir. Thank you, sir.
All right, good luck to you, Mr. Ross.
Thank you.
All right, let's give
Judge, can I make a quick announcement?
let's give Judge West a try again. It looks like somebody finally got her attention and got her to unmute herself.
Good morning, ma'am. Are you Ebony K. Broussard? And Mr. Nix, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. Broussard, in cause number 19-32806, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st, 2020 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 19-32518, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the offense of escape while arrested or confined, a third-degree felony, and that was a 10-year deferred probation as well. Is that correct?
Yes, ma'am.
And then finally, in cause number 21-36615, I have a motion to revoke your unadjudicated probation. This shows you were placed on probation July 12th of 2021 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count 1 in each case alleges that you failed to report as directed to the probation department March 18th of 2025, and is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 in each case alleges that you failed to immediately report to the probation officer your 2024 tax return documents, and is that true or not true?
True.
And then finally, count 3 in each case alleges that you were behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them with Mr. Nix that shows that the district attorney's let's see. All right, so before you went over these, did you, good grief, before you signed these, did you go over them with Mr. Nix?
Yes, ma'am. I did.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made in all of your cases, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is to continue you on probation, to order as a condition of that probation that you enter and successfully complete the cognitive track of the ISF program. And
Computer was being a little temperamental.
what that is intended to say is that she's in good faith going to pay the money that she has up front via her family, the $2,040 as a good faith effort towards her fees.
Okay, and so you have that $2,040 now, and somebody's gonna get that paid?
I do, Your Honor. They brought it to me in cash, and I'm gonna write a firm check for the actual amount as opposed to handing them cash.
Sure, okay. And that's your understanding of your agreements in all of your cases, is that correct?
Yes, ma'am.
And, let's see, it looks like this one did the same thing. When you're done, Mr. Nick's signature's not coming through. What a fun day with technology. Oh. Did I do that? I could have done that. That could be me. All right, so state tender's number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Broussard's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 in each of your cases freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations, but I'm not going to do that. It sounds like probation's here. Like everybody wants to work with you so that you can be successful on these probations. So you need to really go to ISF, learn the tools that'll help you make better decisions so that when you get out, you still have no felony conviction on your record.
And Judge, based on Ms. Johnson's request and some interactions with Ms. Broussard
Uh-huh.
as well as those jail incidents, you might want to fill the court in a little bit more. She needs a little bit of admonishment on her attitude.
Okay. Is there some jail, do I have some jail reports on this one?
Have them here, that would be helpful.
Well, I think I probably went through them yesterday.
Here's the latest one.
That's okay, I've got them right here. Thank you. Mm-hmm. So it doesn't look like you like following the rules is what this appears to me to be. And so here's the thing. If you're not on a felony probation ×3, you can do whatever you want. You can run around your house naked. You don't have to wear your jumpsuit a certain way. You don't have to follow anybody else's instructions. But when you're on felony probation, you have to follow rules that you may or may not like. You have to be respectful to people who are in charge of you, who are just doing their job. Your probation officer and out at the jail. And how old are you? 40 years old and you're doing this nonsense in our jail? This is the stuff, this is the stuff that I keep reading about the young ones in our jail. Not that being in jail is a role model, but you're old enough to be there and say, look, I'm doing better. Do better there. Encourage others to do better. Encourage the younger ones to do better. Don't encourage them to do worse. There more that I need to know about?
No, ma'am. That's pretty much how it's been is, with the attitude, it's following instruction. And when we give her instruction, she usually gives us some pushback. So yes, that's pretty much
Okay.
the whole.
So this is your second opportunity.
Yes, ma'am.
You're not going to get a third opportunity.
Yes, ma'am.
In one of these cases, just one of these today, I could send you to prison right now for 20 years.
Yes, ma'am.
Today, I could do it right now. I don't have to take agreements on these motions. I can do whatever I want within the realms of the law and the realms of the terms on each case.
Yes, ma'am.
2 to 20, 2 to 10, up to 2 years. I could do all that right now today. If you continue to be disrespectful to your probation officer or out at the jail, then you're going to be back in here and it's not going to be nice. Do you understand? I don't care if you have young children. I don't want to hear any excuses. Oh, be nice next time because I have young kids or I need to be there for somebody. Change it, change your behavior so that you can take advantage of this opportunity.
Yes, ma'am.
Okay.
I'm sorry, Ms. McCary.
Thank you. All right, then, I'm going to, again, continue you on probation, order that ISF in each of the cases, and then when you're out, as soon as you get out of ISF, go straight to probation and continue that probation, hopefully successfully, so that you can finish it, get off of it, and not have any convictions.
Yes, ma'am. Thank you.
If I
Yes.
can have one thing, and even though it's not part of the agreement, it's everybody's understanding when she gets out, she's gonna bring her tax return, which is one of the violations.
That's required. So, okay, so it's not that hard to do. So when you do it, it's just another one of those things. Follow the rules.
Yes, ma'am. I sent it to
Hang
her.
on, listen, just, you need to do everything that you're supposed to also on probation's time frame
Yes, ma'am.
and not your own.
Yes,
All right, so it's very important when they ask for something, get it done immediately. When they ask for it, not sometime futures, don't make them ask for things over and over again, all that kind of stuff, okay?
Yes, ma'am.
I'm going to hand you in just a second, hopefully, the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I don't hear anything happening though. And at least, let's see, hold on that first one, the second one's fine. The first one needs Mr. Nick's signature, and let me check the third one. Did two print or just one? So that's 06. So I need, I'm about to do 15. And none of y'all's signatures came up on this right to appeal, but I went through it with her, so I'm going to sign it and do it. Is this all because of the update? Or what is happening?
I don't know. This is the type of problem we had last week, or yesterday and last week. Things just disappearing.
Okay, here's those documents, Mr. Nix.
Judge.
All right, good luck to you, ma'am.
So as Ashley in the chat is rattling off show after show after show after show after show and after show, the only thing I could think of in my head was Bubba from Forrest Gump as he's listing off all of the different ways to make shrimp. Shrimp salad, shrimp stew, shrimp gumbo. You can bake it, you can broil it, you can saute it. That's just what popped into my head. I don't know about you guys. Let's do something new, because we can't have enough new today, I think. Let's go to the 14th district in Kansas. Normally we go to the 13th. This is Judge Jeffrey Gettler. I've never watched him before. Let's discover him together.
1, Mr. Dixon appears by Zoom from the court laptop with, but separate from counsel, Mrs. Hearn, stayed by Ms. Plashka. This is originally set for attorney review, and I believe that Mr. Dixon retained you, Ms. Hearn, is that right?
Yes, Your Honor.
All right. So he has obtained counsel. This is a felony matter, so are you wanting to set this for a preliminary hearing, have a settlement conference? What would you like to do?
Mr. Dixon has turned in a diversion application. We've had a lot of communication. He and I and myself and the state. I'm okay with setting it for a settlement conference. I think it's useful either way. So I think that would be appropriate if that's what the state wants to do.
That's fine.
July 29th at 1 o'clock.
If the diversion application has been received, do you want to move forward with the settlement conference? Or would you rather set it on the August docket to allow the diversion application to come through?
I think setting it to August is better for several reasons, time-wise, and I'm not available on the 29th.
So August 26th?
That works for the state, Your Honor.
That's fine, Your Honor.
And then at 1 o'clock or 9?
I would be okay with either one. I have a 9 o'clock Zoom, but it won't be very long. So either later in the docket at the 9 o'clock or afternoon, either one is fine for me.
All right, we'll set it for 9 o'clock on August 26th. And that'll be for, we'll call it diversion review. And if there isn't a diversion application, at least on file by that date, we'll move forward with getting a set for a settlement conference or separate preliminary hearing.
Thank you, Judge.
And I unmuted me, Ms. Hearn. We're getting some feedback on your end. You're welcome to unmute.
Did you say 1 o'clock?
I said 9 by Zoom.
Okay, the computer skewed your voice.
All right, that's all on Mr. Dixon. You're free to go. Thank you, sir.
Thank you.
State of Kansas versus Elena Bird, MGI 24 CR 381 and MGI 25 CR 136. Ms. Bird appears by Zoom with the separate from counsel, Ms. Hearn, stayed by Ms. Plashka. These matters set for review. I do show there is a motion to revoke bond also on file. It looks like there might be, hang on one second. Ms. Hearn, do you have like the YouTube feed up or something? Are you connected twice? I'm getting a lot of echo on your end.
I don't know that I do, but I was muted till just now.
I just now, we're getting feedback.
I'll just keep it muted if I'm not talking.
Okay. Looks like we were last set for hearing on June 3rd. That was for a settlement conference, and my vague recollection is perhaps an offer had been extended and was being considered by Ms. Bird. I could be mistaken. And we passed the matters to today. In the interim, as I mentioned, there is a motion to revoke bond that was filed on June 27. That the result of a bond violation memo being filed on June 25th that alleges that Ms. Bird failed to refrain from using drugs, specifically testing positive on that date for amphetamine, methamphetamine, and MDMA. How would counsel like to proceed today?
It believes that a sanction would be appropriate for this defendant, given the positive drug screens on this matter. Would leave the time of that sanction to the court's discretion.
Your Honor, I've only just this morning had a chance to talk to my client about that motion. Before there's a sanction, I would like to talk to her some more so that I can prepare a better argument as to that motion. And then as to the rest of the case, at our last hearing, it had said today we would need to set a plea hearing or a preliminary hearing, and we're prepared to set for preliminary hearing when you get to that.
Okay. And Ms. Hearn, you were not available on my July 29th docket, is that right? And I did mute you because of the feedback. So we're looking at either July 29th at 1:30 or August 26th at 1:30 for a preliminary hearing.
The 29th in the afternoon, I am available. It was just that morning docket that I'm not.
Okay. Does that work for the state?
Yes. Well, let me check witness availability, Your Honor. Yes, Your Honor.
All right, then we'll set both these matters for preliminary hearing on Tuesday, July 29th at 1:30. That'll be in person in Independence. Regarding the motion to revoke bond, I'm gonna basically table that for now. We'll allow Ms. Hearn an opportunity to address that with her client. We can take that up on July 29. Ms. Byrd, I would simply advise and admonish you that if you are using illegal substances, that clearly is against the law and it's in violation of your bond. And certainly if there are additional positive drug screens between now and July 29, then it's virtually certain you're going to be spending some time in jail as a sanction. You still might anyway in light of this alleged violation. But I suggest you get things turned around. But we'll allow you time to visit with your attorney regarding that, since that motion was just recently filed. And we can take that up on July 29th at 1:30 in Independence. Anything further on Ms. Byrd's cases today?
Not from the state, Your Honor.
Not from the defense, Your Honor.
All right, thank you. Mr. Jones? Is your
Yes,
client
sir.
appearing with you today?
No, that's Mr. Hoffmeister.
Oh, I know that, but I just didn't know if you're expecting Ms. Parks to be appearing with you.
Expecting her to log in via Zoom, Your Honor.
All right. Well, she is not, so I'm welcome to, you're welcome to stick around and we can take it up if and when she joins.
Judge, I'm the supervising attorney for Mr. Jones. He's on probation right now at our office. I'm just making sure he's following the law and doing a diligent job in representing clients.
I appreciate that oversight, Mr. Hoffmeister. So, Mr. Jones, you want to stick around? I can holler if Ms. Parks joins us. As of now, she's not signed on.
Your Honor, I'm gonna stay logged in. I'm gonna turn my video and audio off. If she does log in, please holler.
Okay. I will do that. Yes, thank you.
Thank you, Judge.
State of Kansas versus Lucretia Hart, MGI 24 CR 354.
Robert Latin appearing, Your Honor.
Morning, Mr. Latin. Ms. Hart does not appear. I believe there's still an active warrant for her arrest for having previously failed to appear on February 13. State appears by Ms. Plaschka. We're set today, I believe, on your motion to withdraw. Is that right, Mr. Latin?
That is correct, Your Honor. I have had no contact with her. I don't know where she's at, so thought, well, I'll just withdraw until we find her, you know.
Any objection to allowing Mr. Latin to withdraw until such time as Ms. Hart is found?
No, Your Honor.
All right, we'll go ahead and grant your motion to withdraw. Mr. Latin, now at least allow you to submit an invoice to bids and get paid for your services to date. And then when Ms. Hart is located, you can anticipate being reappointed.
Okay, that'd be fine, Your Honor. Thank you.
All right, thank you.
Okay, as we continue to set records for the numbers of shows we can name in the chat, let's go back to Georgia and Fulton County.
Good morning, Mr. Coffey. Ms. Washington, may I get the history, please?
Yes, Your Honor. 37 arrest cycles. Prior to this case, there was an FTA from 2025. There was a no-low plea in 2025, March, for theft by shoplifting. There is an open pre-indicted case from 2024 for 2 counts of burglary, criminal damage to property second, and willful obstruction. There's a 2024 misdemeanor conviction for criminal trespass, willful obstruction, and simple assault. A separate 2024 misdemeanor conviction for criminal trespass, disorderly conduct, simple assault, and theft by taking. A 2023 felony conviction for terroristic threat and interference with government property. 23 misdemeanor conviction for willful obstruction and disorderly conduct. A 2020 felony conviction for terroristic threat and willful obstruction. A 2017 felony conviction for aggravated assault. A separate 27 felony conviction for terroristic threat, willful obstruction, criminal damage to property, DUI, and aggravated assault. In 2014, there was a misdemeanor conviction for theft by shoplifting. And also in 2017, there was an arrest for theft by shoplifting, but that case was dismissed. Nothing further.
Thank you. And Ms. Harris, if you can remind me, why was this case reset I believe it was reset from last week. Is that not right?
I'm actually not sure, Your Honor. I'm sorry, you gotta bear with me. I just got this half of the calendar this morning.
Okay, yeah, you're fine, Ms. Harrison. Let's see. First, can you tell me what the current bonds are?
Yes, for the first case, the position 8, position 8 was the theft by shoplifting and willful obstruction. For that case, I have a bond set at
All right, I'm going to interrupt just real quick so we're all clear. I have no problem with you guys and what you're doing in the chat. Have at it. The chat is there to chat. I was just noting that we were setting records. I don't know how many more shows there are left to name, but I'm sure we'll find them. Anyways, back to court.
and I was actually in the midst of the third one. Give me just 1 second. And I'll get you that amount. For position 10, the bond was a $50,000, I'm sorry, not 50,000, a $50 cash bond. And that was issued by Judge Law on June 7th. Okay.
All right.
And
Thank you.
You're welcome.
1 second, please, Your Honor.
And Your Honor, the case is reset from last week because the state asked for extra time.
Okay, thank you, Ms. Young.
That's why it was reset.
Thank you.
Thank you, Ms. Young.
Judge, okay, I'm ready. So
Hold on, Mr. White. Ms. Harrison's not completed with her presentation yet.
Oh, I'm sorry.
Okay, we ready, Your Honor? Okay.
Yes.
Okay, for the first case, position 8, the state's recommendation is count 1, 12 months probation, served 90 days, credit for time served 26 days. The defendant was incarcerated since June 6th with the balance probated, an anti-theft course, 40 hours of community service, a $500 fine, a stay away from the BP gas station located at 464 Windsor Street Southwest.
Ms. Harrison, I'm sorry to interrupt you, but as this is just a bond hearing, I just need to know the facts.
I'm so sorry. I don't know why I was thinking non-negotiated. Okay. Yes. On 11/1/2024, officers were dispatched to the BP gas station at 646 Windsor Street for a call of property damage. When they arrived, the defendant was in handcuffs and he was being detained by security guards. When officers asked to have his handcuffs removed, he was very aggressive and intoxicated. They asked for his name. He wouldn't give it to him, and he continued to cuss officers out. They switched the handcuffs with security and put him in the back of the car, and he continuously kicked the patrol car door as well as spit across the car multiple times. The second incident for position 9, the criminal trespass and damage to property. This incident occurred on May 17th, officers were dispatched to 884 Rose Circle Southwest in response to individuals inside a residence unlawfully. When they arrived on scene, they were met by Mr. Hamilton, who called 911. He works for Sovereign Realty and Management, and he stated that he tried to open the front door, and the defendant answered the door, trying to persuade him to enter. He went back to his car and waited for officers to arrive on scene. And when officers arrived on the scene, they observed the front door open and they saw people roaming about inside the residence. They approached the door, announced, and asked for everybody to come out with their hands up. And they spoke to 2 black males walking up the street from around the house that matched the description that Mr. Hamilton had given the officers of the people that were inside the house. One of the people identified himself as Mr. Coffee, was told to get down on the ground, and he did not comply with officers. Officers had to use a taser to gain compliance from him, and they were subsequently able to place him under arrest. They noticed that the door was in working condition, and but they did see damages to the door on the house. The third incident, Your Honor, occurred. Give me just 1 second to get back to that screen. So theft by shoplifting occurred on April 28th. And officers responded to a call. Sorry, honestly, it's freezing. Okay. Officers responded to a call at 507 Joseph E. Lowry Boulevard, which is the Chevron gas station, regarding a shoplifting. They met with the store clerk, who advised them that the defendant walked into the store around 7 a.m. and proceeded to go over to the first cooler. They asked him, he had a red bag, which he used to place 2 cans of Rita beers, valued at about $9, into the bag, and proceeded to walk out the front door. But he threw down his EBT card, and the store informed him that they don't take EBT, and he never subsequently paid for the beers, and officers were able to corroborate that incident with surveillance video. The state's recommendation, Your Honor, in each case, the first case, position 8, so it's theft by shoplifting and willful obstruction. The state's recommendation here is $1,000 on each charge or surety bond, a stay away from the BP gas station located at 464 Windsor Street. For the second case,
Harrison, are you there?
She walked away, Your Honor. I don't know if something happened to her audio.
Okay, thank you, Ms. Young. Ms. Lewis, are you with me?
Yes, Judge, I'm here. I'm sorry.
Would you give me a call? Would you give me a call, please?
Yes, I can.
Thank you. Court will be at a brief recess.
Okay, well that court's in recess. Let's go back to Judge Bowtie.
06.
Thank you.
You might give him a call in a day or two, Mr. Hawk.
Okay. I'll probably do that after I get off work. I get off at work at 3 o'clock, so.
Well, you might wait probably at least until Wednesday or Thursday.
Okay.
He will not have received the order appointing him, so he won't know who you are while you're calling.
Okay, alrighty.
You might give him a couple days to get notified by the court and to get access to your case information.
Alrighty. Yes,
All
sir.
right.
Yes, sir.
As far as next court date, Ms. Plaschka, July 29th at 9 o'clock work for you?
Yes, Your Honor.
Ooh, sorry about
All
that.
right, you're fine, Mr. Hawk. Your next court date, July 29th at 9 o'clock by Zoom. You're welcome to return here and use our laptop if you need to, or if you have the ability to get logged on to Zoom on your own, you can do that as well.
Okay. Yes, sir. Thank you.
We'll see you then. Thank you very much.
Back, okay.
All right. Thank you.
Thank you.
State of Kansas versus Michelle Shannon.
Judge West has somebody back in front of her. Let's go there.
Mr. Johnson, in cause number 242044, you're charged with a first-degree felony offense of arson, intending damage to a habitation or a place of worship from August 1st of 2024. And how do you plead to that charge? And are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. Any fine?
No fine, Judge.
Is there restitution?
We're gonna I don't believe there is any. It doesn't appear that there is that has not been already satisfied, but just to be on the safe side, we'll take a look at that.
Okay.
Dependency PSI if we may.
All right, is that your understanding of your agreement? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent? All right, sir, I'm going to find that you entered your plea of no contest freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and that'll give me more information about you, your case, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you, Your Honor.
Yes, ma'am, thank you.
Thank you.
See, Ms. Holmes, you have Christina George. What are we doing on that?
Yeah, that's the one with the safe P.
Okay.
So, I guess could we reset a couple of weeks, I guess, to see if Hardin County can put the hold on her and
Yes,
come get her?
that would be very helpful. Yeah,
Yes,
let's
ma'am.
reset Ms. George 2 or 3 weeks.
Okay.
All right, let's go back to Fulton County. It looks like they're back on track now.
Hold, as well as she cited to 20F25, excuse me, CR 002800F, which is, let's see. Trying to see if that was another case on our calendar.
That's position number 9, I believe.
9. Okay, so she cited to that as well for the reason that she did not agree with a bond less than $50 in cash. It looks like the defendant has quite a few theft by shoplifting cases open, as well as the criminal trespass and damage to property case, which is why the bond was set as it is, as well as she stated a judicial hold. It looks like that judicial hold is from a from a willful obstruction, terroristic threats, interference with government property case under 25 SC 002616. So he has quite a number of open cases as well as that hold, which is why, and he does have an open burglary, unindicted, burglary, criminal damage to property, willful obstruction, burglary, second degree, 24 DA 12347. That occurred December 14th of 2024. And a different open criminal damage to property. Well, nope, that looks like it was closed. That was a September criminal damage, criminal trespass, willful obstruction, and burglary in the second degree that was subsequently closed. He also has an open 25 SC 000470 criminal damage to property in the second degree and criminal trespass case that is also open. So, you know, it's talking a lot just to say he has a lot of open cases, Your Honor.
Okay. Thank you, Ms. Falk. Yes, Mr. White.
Thanks. Yes, Judge. War and Peace. So we got, we're just asking for a $2,000 total bond, surety bond on the 3 cases. The FTA that pretrial mentioned earlier was one of these cases where the notice went to the wrong address. He's had the same mailing address for his whole life. And this one went to, it was one number off apparently. Should have been 880, went to 800. He has a disability hearing coming up this week that we would like him to be able to get to. He has been in touch with our social workers. They've lined up a whole series of things for him to do when he gets out, including going to 10 Park Place. And there's some help there that they've already put in place for him, I think. So we're just asking, his mother can bond him out if it's $2,000 surety bond or less. So that's what we're asking for, Judge. He has been in jail also 28 days at this point since those bonds were set. And obviously he has not been able to make it.
Okay. The bonds for positions 8 and 10, I'm going to leave as set. The bond for position number 9, the criminal trespass and damage to property, I will lower that to $1,000 good bond with all the conditions that were in the initial bond. So if you'll prepare that, Mr. White, we'll get it signed. Good luck to you, Mr. Coffey.
Right, so that's going to be, what's that? Position 8.
I'm sorry, y'all.
What is the number?
Whatever the bond is, and I was told it was $1,000 good bond, so I take it that's $500 per charge. That's what I was told previously. So
I just want to make sure, Judge. So I've got 2,000 surety and a 50 cash. Is that correct?
what I was told was position 8 was $1,000 good bond, position 9 was a $5,000 good bond, and position 10 was a $50 cash bond. I am lowering position 9 to $1,000 good bond.
That's what I do, Judge. I just want to make sure that we're
okay. All right. So, Miss Lewis.
Yes, I got a question, Judge. He's only being held for 2 charges. His total bond is $1,050. He's not being held for the other 2. Only two charges on his booking screen right now is theft by shoplifting, misdemeanor of the offense of April the 28th of 2025 of a $50 cash bond, and the rearrest that they surrendered him on the pretrial bond of $1,000 for the criminal trespass damaged property that happened on May the 17th of 2025. So his total bond is only $1,050 to get out. I just want to clarify, just letting y'all know.
So just to be clear, it's $1,000 surety plus the 50 cash is what you had?
That is correct.
Mm-hmm.
Okay.
He's only in there for 2 charges. He's not in for all the rest of the charges that y'all are indicating on his count. He's only booked in for the 2 cases.
Right. So just to let the court know, the bond that you modified and reduced to $1,000 surety, position 9, that was already $1,000 surety. It was a $5,000 signature bond through pretrial services. They then surrendered that bond and turned it into a $1,000 surety bond.
That's correct.
So, Your Honor, essentially, the bond is still remaining as it was originally set once his bond was surrendered. Is that tracking with everyone?
That is tracking with me. It's correct.
I know with you, Miss Lewis.
It's correct. That's why I didn't want it when y'all was saying 2,000. I was like, what? Y'all making the bond higher than what it is.
Just so we're clear, what paperwork needs to be done, Ms. Lewis? Do we need to? Does any additional paperwork need to be done, or are we good?
If you're going to keep the bond as it is, that he's in jail on, then there's no paperwork because he just got to post a $1,050 bond unless y'all, it's a cash bond and $1,000 surety.
Okay. So we went.
I'm just saying y'all doing extra paperwork for nothing. That's all I'm saying.
We went to that 25 minutes of. All right. Good luck to you, Mr. Coffey.
And my apologies for the confusion, Your Honor.
No worries. Are we good, Mr. White?
Yes.
Okay.
Yes, Your Honor.
All right. Where to next?
Good morning, Judge Morrow. Hope you're doing well. I have position
number 32, Ms. Janice Smith.
Good morning, Francois. I am. I hope you are as well.
Thank you.
This is going to be a negotiated plea, is that right?
It is, Judge.
32?
Position 32, yes, Judge.
Okay. And negotiated plea, is that right?
Yes, Judge.
Good morning, Ms. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Speak up for me or scooch up for me.
Yes, sir.
All right. Thank you, Ms. Smith. You can put your hand down. Thank you. Yes, Ms. Harrison.
Yes, Your Honor. For count one, loitering and prowling, the state's recommendation is 12 months. Probation served 34 days. Credit for time served 17 days. The defendant has been incarcerated since June 15th. Balance probated. Stay away from 1263 Gus Thornhill Drive. Completion of ADET. And for count two, possession of drug-related objects. 12 months probation concurrent with count one. We ask that the defendant stipulates venue, ID, and facts of the case for purposes of the plea. That'll be all for the state, Your Honor.
Connor, we stipulate, due to the nature of the charges, I would ask the court to consider non-reporting upon completion of the ADET, Judge, and of course, stay away stays into effect, Judge.
Okay. Ms. Smith, it's my understanding that in case 25 CR 003361G, you wish to plead guilty to loitering and prowling and possession and use of drug-related objects. Is that correct? Okay.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? Scooch up again for me.
No, sir.
You've been represented by counsel. Are you satisfied with his representation? Say it again.
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes,
Was
sir.
that a yes? Has
Yeah.
anyone forced you to plead guilty?
No, sir.
All right, I'll accept the plea as negotiated, Ms. Smith. When you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees, okay? All right, good luck to you, ma'am.
Thank you, Judge.
Welcome.
Get out today.
All right, friends, I'm going to go ahead and say it now. Tomorrow, we will do Music Day. So think about your most obscure music references and we'll go there. But let's stay on task and keep it to TV shows today. We have fun here. You got to say that. Let's change it up a little bit. Let's go to Michigan, and we'll spend a few minutes with Judge Mom because we haven't seen her in a while.
All right, on examination of complaining witness, I find that the offenses occurred, the offenses charged were committed, there was probable cause of lead to commit those offenses. And counsel, your appearance, please.
Good afternoon. Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment will wait for more reading, my client stands mute.
Okay, ma'am, your name for the record, please.
Shayna Hunt.
All right, and so the court will waive the formal reading. You do have the right to have an attorney represent you. And if you could not afford one, you can have one appointed to represent you. Do you understand that, ma'am?
Yes, ma'am.
You have, in fact, had an opportunity to speak to an attorney today, correct?
Correct.
And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used in court against you. Do you understand that?
Yes, ma'am.
All right, the court's going to enter a plea of not guilty, and we schedule this matter for probable cause conference on July 10th at 9:30 a.m. And counsel asked to bond.
Your Honor, as to bond, my client is currently 33-year-old. She lives in Newport. She has a 15-year-old son. She works full-time at Special Tree Rehabilitation Center. She's a nighttime program manager. Judge, I'd be respectfully requesting any consideration with leniency in determining the bond, potentially consideration for a personal bond. Thank you, Judge.
All right. And so, ma'am?
Yes, ma'am.
If you're in a test right now, what is in your system?
Nothing. I mean, I drank on Saturday, but other than that, I don't believe anything.
All right, and ma'am, how many children do you have?
One son who's 15.
All right. Have you ever failed to appear in court for any reason?
Never.
Are you currently out on bond in any jurisdiction?
No, ma'am.
All right. And Sergeant Oborn, as to bond.
Yeah, I'm gonna ask for 10,000 on this case as well. It is a felony charge for possession of cocaine, which was in her possession. This is also her second offense for OWI within 7 years.
All right, ma'am, where is your son right now?
Currently he's in driver's training class right now, but my mom's been helping with him the last few days.
Okay, where does your mom reside, ma'am?
My mom lives in Wyandotte.
All right. All right, given the nature of the charges, the allegation of the possession of cocaine, as well as the operating while intoxicated second offense charge, and the court's going to order a $7,500 10% bond. In the event we post bond, ma'am, you're not to be released without a GPS, without an alcohol tether through the Wayne County Jail. The court wants to ensure the safety of the public. You're not to possess or consume any alcohol or drugs unless prescribed. Any questions?
No, ma'am.
All right.
How do we, so I guess I do have a question, my apologies. The 10% of the 7,500, that's $750. I can pay that right now. I just need access to my personal belongings that the officers have. I can take care of that part right now.
All right, so on that note, ma'am, do you have an additional $192? Because then the tether unit can come to you.
An additional 192 on top of the 7. I believe I do. I just have to get onto my bank app and just confirm, but I believe that would be about 809. Yes, I believe so.
Okay, I'm not sure what the procedure is at the police department, Sergeant Oborn. Does she get access to that or no?
Yeah, the sergeant on the desk will let her get to it when he gets time. I don't know how they're gonna take for the tether. I mean, we can do the bond here for her personal, for her bond, but for the cash for the.
Is there any possible way I could report for the tether?
Please stop, please. The tether would have to be prepaid by card. So if she has a card, that would be prepaid and then they would come down and do that. So, that's my question. Do you have the additional funds on your card or a card or anything, ma'am? To pay for that?
Ma'am. Yes.
Okay, so my question then, Sergeant, is I don't know the procedure from the Wyandotte Police Department if an individual gets access to their belongings to access whatever payment methods they have to post bond.
Yeah, she can get to her credit card or debit card. She can get to that.
Okay, and then probation will coordinate as far as the communication with the tether, EMS tether, so that she's not being released without the tether individuals being down here, being down at the Wyandotte Police Department court lobby here. Is where they'll arrive here and then they'll fit her with the tether. Okay? And if she doesn't have the funds, then she takes the ride down and gets the Wayne County jail covered.
Okay.
Okay. All right, thank you. We'll see you back on the 10th. Thank you. Have a good. Okay. And then Sergeant Lawyer here, do you want to do the swear to for Mr. Story?
Yes, Your Honor, I'm ready for it.
All right, we are still on the record in the matter of the state of Michigan versus David Story, 25911. And your name for the record, please.
Sergeant Stephen Oborn, O-B-O-R-N-E.
Okay, and you are still under oath. You may proceed on the warrant.
On 3/4/25 at approximately 17:37 hours, Wyandotte cars were dispatched to Biddle Avenue and Cedar Street for a hit and run accident that had just occurred. Officer Carpo was the first officer on scene. She advised other Wyandotte cars that the hit and run suspect vehicle was a white Dodge Ram with the plate of EGU 5790. Last seen heading southbound on Biddle. Suspect vehicle actually struck two different vehicles. The first was a Dodge Charger and the second was a Jeep Patriot. Prior to the vehicle fleeing southbound on Biddle, the driver of the vehicle, who was later identified as David Story, dropped off the front passenger, Jonah Mazuka, in the Wyandotte Police Department parking lot. Officer Carpo spoke with Mazuka, and she explained that she and Story were driving around doing errands, and Story would stop at different party stores and purchase shooters and then consume them. Mazuka also stated that Story was highly intoxicated. Officer Rasmussen, who was in a fully marked patrol vehicle, located the suspect vehicle traveling southbound Biddle near Eureka. Officer Rasmussen followed the vehicle and observed the driver, David Story, swerving inside his lane and reaching speeds over 45 miles an hour in a posted 35-mile-an-hour zone. As Officer Rasmussen and Story approached Central Avenue, Officer Rasmussen activated his emergency lights. Story disregarded the lights and continued southbound on Biddle, changing lanes without signaling. As Officer Rasmussen and Story approached Pennsylvania, Story stopped his vehicle. Officer Rasmussen, along with Officer Sadowski, then attempted a felony stop. Officer Rasmussen and Officer Sadowski gave verbal commands for Story to roll down his window. Story ignored all the commands. After about 60 seconds, Story decided to accelerate and continue heading southbound on Jefferson Avenue in the city of Riverview. At this point, Officer Jones assisted in the pursuit. Officer Rasmussen, Officer Sadowski, and Officer Jones pursued after Story using their emergency lights and sirens. Story reached speeds again near 45 miles an hour in a 35-mile-an-hour zone, still having a hard time maintaining his lane. Story approached Sibley Road, where he briefly stopped at the intersection and then disregarded the red signal and continued southbound on Jefferson. As the pursuit reached King Road, Trenton Police Department joined the pursuit. Wyandotte cars were then terminated by their OIC. Trenton Police Department ended up taking Story into custody and taking him to Corewell Health Trenton Hospital for treatment. See Trenton's police report for that details. Officer Rasmussen completed a search warrant for blood and had Judge Zelnick sign the request. Officer Rasmussen then met with Trenton PD along with Story at Corewell Health Trenton Hospital and obtained blood from Story. 2 vials of blood were collected from Nurse Salazar from Story's left arm. The blood was later sealed and placed in the outgoing mail at the Wyandotte Police Department. After checking Story through lean, it showed that he had several prior alcohol violations. 2 out of West Branch back in 2004, and the other back in 2012, and another one out of Allen Park back in 2000, and one out of Woodhaven back in 1993. On 3/18/25, I received the blood results back from the Department of State Police Forensic Science Division, laboratory number TX253235, resulting in a 0.301 grams of alcohol.
All right, upon examination Of the complaining witness, I find the offense charged were committed, there is probable cause to believe the defendant committed the offense. And, Sergeant, you want this, mailed?
Yes, mail's fine, Your Honor.
Yeah, very good, thank you.
Thank you.
All right. All right, we are on the record matter of Justin Carlton, 24416. All right, and Mr. Shumke?
I'm sorry, my name's Justin Carlton.
Yes, I know that, I'm just getting your attorney's first. So, counsel?
Yes, good afternoon, or good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
All right, and, sir, your name for the record, please.
Justin Carlton.
All right, and Mr. Carlton's in custody from a warrant that was issued for Mr. Carlton's failure to appear for probation violation hearing back in September 9th of 24. And that probation violation hearing was scheduled because Mr. Carlton failed to appear for his instruction twice so that he could begin probation. And so, counsel, what's happening today?
Your Honor, Judge, I'd ask that we set the matter down for a violation hearing. I don't want to be sentenced today. I saw what the recommendations are in their 90 days. I just wanted to address his bond. I know that he does have some very positive things working for him. Certainly, he was apologetic for not making the arrangements last year. He's a single father of a 2-year-old. He also has a 7-year-old daughter that he sees and is very active with. And in fact, he has an interview today with the chemical property in Belleville at 1 p.m. I saw the recommendations. I know that those recommendations are based on where he was last year. I just would like the court to be made aware of where he is now, and potentially they can consider an alternative admonishment. So at this point, we're asking that the matter be set down for a violation probation hearing.
Okay, well, we're looking at July 23rd for a hearing. July 21st.
Judge, and it's directly going to be correlated with the potential consideration for bond. I saw that, what the recommendation was for the probation to be closed out and for him to do jail. Judge, in this circumstance with the potential job opportunity looming, especially, I've been made to believe that it would be extremely helpful for his family. Currently, his house is in foreclosure. We'd ask any leniency this court can consider. Obviously, I do believe that at the court proceeding, he'll not be asking for the hearing, and he's not going to contest that he didn't make it. So if we could enter into the plea today regarding the violation and set it out for the sentencing so the court can be made aware. I just don't want him sitting in there. My entire avenue is to demonstrate where he's at now, but I'm never going to have a hearing in which he contests that he actually went, because that will not be the circumstances.
Okay, so Mr. Carlton, where have you been other than ghosting the 27th District Court?
Been taking care of my 2 children the best I can, looking for a job. I don't have a vehicle right now, but the girlfriend does. And I got an interview today.
Sir, how is it that you're in custody today?
I was sitting in the car with the girlfriend in CVS parking lot, and somebody Wyandotte PD stopped in front of us, and I guess recognized me. I don't know how, and that's how.
Sir, if you test right now, what is in your system?
Me? I'm clean.
So nothing would show up in your system?
No.
And what happened with your matter in 36th District Court from your interlock device violation?
I wasn't able to make that. So I don't have a vehicle that's somewhere downtown. Like I haven't had a job in a while. I had no money. I got a daughter that was in school, one that wasn't. My 2-year-old son, he'll be 3 on the 19th this month. And you know, situations with the girlfriend are rock, you know. It's hard to accomplish anything. And this job right here today that I was, you know, the interview was that would have set me.
Sir, why is it hard to accomplish anything?
I'm sorry.
You just said it's hard to accomplish anything. Why is that the case?
I got the case with having 2 children, full cut, you know, under my. I don't have any help from my mother. I don't have any help from my family because I have no family. It's just me and my children and my girlfriend that, you know, we butt heads a lot. It's hard to accomplish. It's hard to do anything when we're not on the same page. You know, it's I got everything going against me right now. And just sitting in a parking lot last night and it ruined my chances for this potential job. It goes to show like that. I don't know. I can't.
You were supposed to have reported back in July. This court gave you an opportunity. First of all, you had a possession charge, and it was amended to a possession of drug paraphernalia charge. And then this court gave you the benefit of the doubt and placed you on probation, despite having a criminal history that involves controlled substance and alcohol. So, I'm not quite sure, and then you were supposed to have been starting Gage Products back in July of 24.
Yes.
Did you start that job, sir?
That job, I was offered the job. I got the offer letter. The situation, it was kind of a savage.
Stop. My question is a simple yes or no. Did you start that job at Gage Products back in July of 24? Yes or no?
No, I did not.
Okay, so sir, you seem to be getting in your own way of not being able to accomplish things. And now you are in custody after you and your girlfriend were sitting in a parking lot where there's known narcotics history or activity, I should say. So
I was there to put money onto my casino at my $8 that I had. I'm sorry.
Excuse me. Further, you have yet to clear up your warrant out of the 36th District Court, which this court instructed you to do as well. And
to lose my children.
I'm sorry?
I'm going to lose my children if I can't make it.
If you can't make it where?
If I stay in here, I'm gonna lose my children. They have nowhere to go. They have nobody to watch them. I'm gonna lose my children.
Sir, then you should make sure that your warrants are cleared up so that you don't get arrested and you can take care of your children. And you should also make sure that you have a job so you can take care of your children, because I'm not sure who's been supporting you and your children over the last 12 months. Whose car were you in? Is it your car?
That was the girlfriend's car.
Well, did the two of you at some point get into a fight? And you may have had a car, because that's why the police were chatting with you regarding a report of the vehicle. Essentially not with somebody that's authorized to use it.
That was days prior. And we had already established that with the Southgate police.
Okay, well, just letting you know, sir, that was why you had contact, not because they would just recognize you.
Oh, so I was still a suspect at that point in time yesterday?
Well, I don't know, I mean, that's what, I'm just looking at the police report, and,
So they could stop whoever whenever they want?
apparently they found something in your possession with you and the girlfriend. Your girlfriend's name is Caitlin?
Yes.
Well, sir, here's the thing, right? I'm hearing that you have an interview. I'm hearing that you have a job when I sentenced you. You didn't start that job. You haven't been working. When's the last time you worked, sir?
It's been over a year.
A year. So how are you supporting yourself and your children without any income?
Donating plasma, any odd job that I can find. I've been plugging away. I could show you on my phone my interview today. I could show you the confirmation. I can promise you that. I'm not lying about it. It's been a struggle. Food pantries. It's been sad. It's pretty pathetic.
Okay, but I can also assure you, sir, that when there's drugs involved, it makes it even more difficult. So, what I'm going to order is I'm going to order based upon Mr. Carlton's failure to appear at this court for his probation instructions in July of 24, then with the rescheduled date of August 21st of 24, failing to contact the court, stating any communication with the court, having a pending warrant out of the 36th District Court that you failed to clear up as well. And given that Mr. Carlton's not currently working, and the court has some serious concerns for Mr. Carlton's ability to reappear in court, the court's going to order a $3,500 10% bond. In the event you post bonds, you're gonna have to be released without a GPS tether through Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed. Maybe you can have your girlfriend contact you, this job that you have this interview at, and see if you can get it rescheduled. And counsel, I have okay. Is your client able to participate in the probation violation hearing on Thursday? Otherwise, it's going to be the 9th with a different judge.
Judge, I know that my client is eager to do whatever he can to put himself in a favorable position with the court. I'm not sure if he'll be able to post the bond, so I certainly don't want to put him in an avenue that would delay his process further. So we are at the behest of the court in any way to be cooperative and speed up this process.
Okay, so do you want July 3rd then for the hearing date?
I would think the sooner the better. Yes, Your Honor.
All right. We can do that at 10:15 a.m.
With the knowledge that would go to the next MIDC individuals. I'm not available that day, but okay.
Correct.
Thank you, Judge.
All right. We'll see you back on Thursday, sir. Okay, thank you. Okay. All right, let's go off the record for a moment. All right, counsel, did you have an opportunity to speak to Mr. Ariana?
Yes, Judge. I also spoke with Miss Payne because I called her back when I was waiting. The only individual I haven't spoken to is Sarah Shelton.
Okay, I will put you and Miss Shelton in a breakout room. Where did Miss Shelton go? Well, this might be. Okay.
Okay, we've been with Judge Mom for a little bit. Let's head back to Judge West in Texas.
Good morning. Are you Ray LeBlanc?
Yes, ma'am.
Can you hear me okay like that?
I can hear you.
Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Okay.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices. I'm required to read it to everybody.
I've never owned a firearm in my life.
I've got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Okay.
Good luck to you, sir.
Thank
you, Ms. Holmes.
Yes, ma'am. Thank you. Okay, so, yes, so they have you on the docket today in this court. Your attorney's name is Jennifer DeLay. Okay, so I'm going to contact her to make sure she comes back to see you. They're going to tell them to bring you over to county court right now.
See, Mr. Lewis, you have Derek Ardwan.
Yes, ma'am. I'm telling them to bring you over to county court right now.
Thank you.
Derek Ardwan. Morning. You've been back there working. You got them piled up today. Looks like a gold star in the making. I don't know yet. We'll see. What?
Why does he get a gold star?
Because he's got 3 pages of docket that he's taking care of.
2 of those are mine.
Okay, so y'all can share the gold star. Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment?
He does.
Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me. And I cannot give you more than 6 years. I could give you 6 years, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and determine two things. The first is to decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, as a result of this plea, it looks like you have gone over with your attorney that you will be required to register as a sex offender, and it looks like you've already signed that document and those admonishments. Is that your understanding as well? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Ardwan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he will present it to me on your behalf when we come back. All right? You can go back with the bailiff. See, Colton Armstrong.
That one, Judge, I think Bruce Smith filed a motion to sub this morning.
Oh, just this morning? Great. Looks like Colton Armstrong's going to be reset. If you'll make a notation that he's supposedly hired Mr. Bruce Smith this morning, and so we can be kind of watching for a letter. James Burrell, Mr. Lewis.
Yes, sir.
Good morning, sir. Are you James Burrell? Yes, ma'am. And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Burrell, in clause number 22-39838, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation May 23rd of 2023 for the third-degree felony offense of theft, and that was a 10-year term in prison that was suspended for 10 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 14th, May 23rd, June 11th of 2024. And is that true or not true? Count 2 alleges that you failed to immediately report to your probation officer your change of address and phone number. Is that true or not true? I'm sorry? Okay.
I think the state would be willing to waive counts 3 through 5. However, we'd be asking for some sort of a plea on 6 and 7.
All right, so the state's going to abandon 3 through 5. Count 6 alleges that you were arrested for the offense of possession of a weapon by a felon June 19th of 2024 in Orange County, Texas. And is that true or not true? And then count 7 alleges that you were arrested for possession of a controlled substance June 19th of 2024 in Orange County. Is that true or not true? Did you enter your pleas of true to, I'm sorry?
No.
Oh, I thought I was going to say.
No.
Did you enter your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Burrell is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you back when you first got probation, right? So just make sure you read that and know that because of this judgment, you cannot possess a firearm.
Yes, ma'am.
All right, good luck to you, sir.
I thank you. All right, thank you, Ms. Williams.
Yes, sir.
So I don't know how this is coming across on your end, but I got to tell you, this has actually been a very difficult day to put together a show for you. Not just because of the chat going crazy for that 45 minutes or so with trying to keep up with all the TV shows, but it's been a weird court day. There's a lot happening, but not a lot going on, if that makes any sense. A lot of courts in session, but not a whole lot going on in those courts. So it's been a bit of a challenge. So I hope the show's coming across okay. Doing my best here, let me tell you. But let's go back to Fulton County. That is one place where it's been fairly consistent.
Ms. Washington, may I get Mr. Hendricks's history, please?
Yes, Your Honor. Please just hold one moment.
And while you're doing that, Ms. Lewis, are you with me?
Yes, sir, I am.
On positions number 7 and number 17, I have conflict down. Do we have a conflict attorney that's, and I'm not sure whose cases those are. I haven't seen Ms. McLeod come on with us this morning, so I'm not sure if they're her cases or not. Will you check on that for me?
Can you give me the names of the last name? Because I think the count is kind of off on me.
Okay, I believe Calvin Butts and Nicholas Gonzalez Ramirez.
Okay.
Thank you. Yes, Ms. Washington, whenever you're ready.
Yes, 11 arrest cycles. The last arrest appeared to be from April of this year out of Cobb County for simple battery. There was also an arrest in August of last year for willful obstruction out of Clayton County. No disposition was listed. In 2024, there was convictions out of Spalding County, including 2 counts of theft by shoplifting, simple battery, and 3 counts of willful obstruction. There is also a probation violation in 2023 and 2022, an FTA from 2022. In 2022, there was a misdemeanor conviction for driving without a valid license. In 2019, there was first offender treatment for a burglary in the 2nd degree out of Paulding County. That was sealed in 2024. There was a 2022 felony conviction for theft by taking out of Paulding County. A 2022 theft by shoplifting and furnishing a person below the legal age out of Spalding County, and nothing further, Your Honor.
Yes, Ms. Harrison.
Yes, Your Honor. On June 16th, officers were dispatched to Rickshaw's High Street Food in reference to a disturbance. When they arrived, they spoke with the victim, in this case, Ms. Laura Rivera. She's an employee at the restaurant, and she informed officers that a male had come into the restaurant asking to use the phone because his car broke down. She offered the restaurant phone to him, and he began acting aggressively and asked to use her personal cell phone. He lay down at the counter bar, and she stepped out from behind the bar to go deal with other customers. And as she did that, the defendant stepped from in front of the bar to behind the bar, and she observed him grab a bottle of Casamigos Añejo tequila. She attempted to stop him from taking the bottle, but he stood in front of her in an intimidating manner. So she allowed him to leave as she was scared. She described him to officers as wearing a green shirt with a face on it, and having face tattoos. And officers recognized that on the drive into the dispute location, they'd actually seen the defendant matching the description that Ms. Rivera gave. They went outside and approached the defendant up the road, and asked him if he had gone into the restaurant, and he stated he did not steal anything. He was not at the restaurant. They went back to the restaurant and viewed security footage and actually confirmed that it was him, and went to place him into custody, and he was uncooperative and refused to give his hands to officers. But they were able to locate the bottle of Casamigos tequila in the waistband of his jeans during a search incident to arrest. Yes, Your Honor. And yeah. And the state's recommendation here, would you like the recommendation?
Yes, please.
Okay. Count one was 12 months probation, served 60 days, credit for time served 15 days. The defendant has been incarcerated since June 16th. The balance will be probated a stay away from Rickshaw's High Street Seafood. It's located at 1495 Alpharetta Highway. Completion of an anti-theft course and 40 hours of community service. For the willful obstruction of law enforcement officers, state's recommendation is 12 months probation with credit concurrent with count one and a $300 fine. For the simple assault charge, the state's recommendation is 12 months probation concurrent with count one and no further contact with Laura Rivera, and also an 8-week anger management course. That'll be all for the state, Your Honor.
Mr. White?
Yes, Your Honor. We're just asking that all of the requirements from the probation recommendation stay in place, and asking to be given credit for time served. In addition, he's willing to add the condition to probation that he checks himself into rehab. And there is a rehab at Serenity Grove in Athens or North Atlanta Behavioral Health that he knows that he can get into. And we would make that a condition within the first 30 days of release in exchange for time served.
What is the name of the rehab facility?
Serenity Grove. The first one he mentioned is called Serenity Grove. It's in Athens. And this would be a residential rehab center. So once he's in, we would just ask that while he is in rehab, he would be allowed to report by phone to probation. It will be at least a 30-day program.
What does the state think of that?
The state does like the proposition. I think we'd be agreeable to that, Your Honor.
Okay. I'd also have him be on probation for the entire 12 months, reporting probation for the entire 12 months. It would be 12 months to serve, 30 days, credit for time served, 15 days. All the other conditions, along with that he is to report to inpatient rehab at Serenity Grove within how long within getting out of custody?
We'd ask for 30 days, Judge, so to make sure that he can organize getting in, family, all of that.
And within 30 days of getting out of custody. Would the state be agreeable to that?
The state is agreeable to that, Your Honor.
Okay, so this becomes a negotiated plea. Very good. Anything further from anyone?
No,
Okay.
from the defense.
Yes, Ms. Young.
You're gonna allow phone reporting?
Yes, I'll allow phone reporting while he is in rehab.
Thank you.
Okay, thank you. Mr. Hendrick, it's my understanding that in case 25 CR 003366F, you wish to plead guilty to theft by taking, willful obstruction of law enforcement officers, and simple assault. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right? Has anyone forced or coerced you to plead guilty? Say it again for me.
No.
And I'll accept the plea as negotiated. I will also require that you be on reporting probation for the entire 12 months, sir. Good luck to you.
Thank you. Thank you, Rob.
You're welcome.
Thank you, Rob. Oh, you're talking. Actually, you can take this. Yeah. Okay, then we'll do that. You're in position 25, Bernard Mitchell. That'll be a negotiated plea.
Okay. Good morning, Mr. Mitchell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. For the charge of simple battery, family violence, the state's recommendation is time served, 302 days, credit for time served, 151 days. The defendant has been incarcerated since October 17th of 2024. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. And that'll be all for the state, Your Honor.
And defense so stipulates for the purposes of the plea this morning, we ask that the court follow the state's recommendation for Mr. Mitchell.
Mr. Mitchell, it's my understanding that in case 25 CR 003403D, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation?
Yes, ma'am.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, ma'am.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Mitchell. Good luck to you, sir.
Next opposition is 30 and 31, Mr. Smith. And Your Honor, this is a negotiated plea. I believe I had initially announced that it would be a waiver of arraignment and an announcement of guilty, but Mr. Smith has decided to accept the state's offer this morning.
Okay. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, indeed, sir.
Okay. You can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. The state's recommendation for battery family violence is 12 months served 38 days, credit for time served 19 days. The defendant was incarcerated on August 28th through August 30th of 2024 and subsequently on June 16th. The balance will be probated, completion of FVIP, 40 hours of community service, no contact with Danielle Robinson, and stay away from the incident location, and no firearms. And for the FTA, it'll be null prost upon the plea of the underlying charge. And the state asks that the defendant stipulates to venue, ID, and facts of the case for purposes of the plea. And that'll be all for the state, Your Honor.
And defense so stipulates, we would ask that Your Honor follow the state's recommendation this morning.
Okay. Mr. Smith, it's my understanding that in case 24CR006105B, you wish to plead guilty to battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yes, indeed.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, indeed.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Smith. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Next is position 37, Mr. Thomas. And this should be a negotiated plea.
Okay. Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. In the charge of criminal trespass, the state's recommendation is 12 months, served 60 days, credit for time served 17 days. The defendant has been incarcerated since June 16th. The balance suspended, Stay away from 3252 Verdant Drive. No further violent contact with Derek Cook. The defendant also does have another case. It's 23CR001206F. The state's recommendation in that case is 12 months, serve 18 days, credit for time served 9 days. Balance probated and no further violent contact with Derek Cook. Completion of FVIP and no firearms. And we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, Your Honor. That'll be all for the state.
What is the charge for the add-on?
It is a simple battery family violence.
Yes, Mr. Massajuddin.
Thank you, Your Honor. Defense so stipulates, for the purposes of the plea this morning, Mr. Thomas would ask that Your Honor follow the state's recommendation.
Mr. Thomas, it's my understanding that in case 25CR003346F, you wish to plead guilty to criminal trespass. And in case 23CR001206F, you wish to plead guilty to simple battery family violence. Is that correct? Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Thomas. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Next is position 23, Mr.
Well, Win, if you keep nodding off, let's try to change things up a little bit. Let's go to Jefferson County Court at Law number 2, Judge Terrence Holmes.
Does he have one case? Two? Just one? Okay, well, okay, Mr. Sanford. Your full name is? Jordan. Jordan,
Yes,
okay. Jordan Clark Joseph Sanford. How are you doing, Mr. Sanford? That's good, Mr. Sanford. Would you please raise your right hand? Sanford, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Sanford, you may put your hand down. How are you doing, Mr. Sanford?
You doing?
You doing okay?
Yes, sir.
Okay, Mr. Sanford, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Mhm.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Sanford, your case will be reset. Give you an opportunity to hire an attorney, but before
Give you the reset, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court Law Number 2. Do you see that document?
Yes, sir.
And it states following return of criminal information in County Court Law Number. This one don't apply. Let me see that. Hold on back. I need to strike through. this stuff. Okay. Get us back to. Okay, now Mr. Sanford, this document is titled Standard Bond Conditions in County Court Law Number 2 following, and it states following return of criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, and B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Okay, do you understand that condition?
Yes, sir.
Okay, and condition number 3 and 4 and 5 does not apply. Okay? Now, if you violate any one of these conditions, your bond will be revoked. You'll be arrested and placed in the Jefferson County Jail. When you have a seat, wait for your name to be called. Once your name is called, okay, you'll be free to go. Destin Gillinger. Mr. Gillinger, your full name is Destin Gillinger?
Yes, sir.
Mr. Gillinger, would you please raise your right hand? Mr. Gillinger, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Gillinger, you may put your hand down. How are you doing, Mr. Gillinger?
Doing all right.
Okay, that's good, Mr. Gillinger. The state is represented in this case by Attorney Sharon Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Mr. Gillinger, I have before me. Mr. Gillinger, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding a Trial.
Yes, sir.
Do you recognize this document? And is this your signature on the line as titled defendant?
Yes, sir.
Mr. Gillinger, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And state, you have
Yes, Your Honor.
passed it off, you given an answer to Mr. Gillinger?
We have, Mr. Gillinger's in the Navy. He said that he's going to pay the restitution today. And if he does so, the state then agrees to dismiss. So I guess we would just ask the court for a resetting for 1 week just to keep it on the docket. But he's told me that he can make sure that that payment is done today.
Okay, now, Mr. Gillinger, your case will be reset to 1 week, for 1 week, and that's, is that July 8th?
Yes, sir.
8 at 9 AM. Now, if you pay the restitution, apparently you'll go to the district attorney's office with the payment. And if it's correct, then the district attorney is going to dismiss the case and you will not have to come to court
Yes, sir.
on the 8th of July.
Yes, sir.
Okay?
Yes, sir.
All right, so your case is reset to July 8 at 9 AM. You can get your reset. Once you get your reset, you'll be free to go. Did you give him that information as to how he's gonna pay it?
I'm sorry, I was about to go.
Okay.
With him.
Here you go.
That would be one.
Oh, that's,
But it doesn't have to be one.
yeah.
They're expecting. Okay. Yeah, I'll go.
Brandon Elliott. Mr. Elliott, your full name is Brandon Elliott?
Yes.
Mr. Elliott, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Elliott, you may put your hand down. How are you doing, Mr. Elliott? I'm doing fine, thanks for asking. Mr. Elliott, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indians. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Elliott, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Elliott, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go, and you have a blessed day. Please have a seat in that chair and wait for your name to be called. Alicia Spriggins. You could come down right there. Ms. Spriggins, your full name is Alicia Rose Spriggins?
Rosa.
Rosa Spriggins? Ms. Spriggins, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Spriggins, you may put your hand down. How are you doing, Ms. Spriggins?
I'm well.
That's good. Now, Ms. Spriggins, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
I do.
And is this your signature? You didn't sign it, Ms. Bailiff.
Yeah.
Okay, now, Ms. Spriggins, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
I do.
And is this your signature on the line that's titled defendant?
It is.
Or these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Judge's Explanation, that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
I do.
On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Ms. Spriggins, before you signed and initialed these documents, did you read the document?
I did.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Spriggins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank
You're welcome. Jaquan Broussard. Mr. Broussard. Your full name is Jaquan Broussard?
Yes, sir.
How are you doing, Mr. Broussard? That's good. Now, Mr. Broussard, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Broussard, you may put your hand down. Mr. Broussard, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Broussard, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct?
Yes,
To the
sir.
best you're not. Mr. Broussard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once she gives you the information, you'll be free to go. And you have a blessed day. Please have a seat
Yes,
in
sir.
that second chair on the wall. Thank
Yes,
you.
sir.
Okay, let's stay in the building, but let's switch back over to Judge West.
What I can do is reject, once he comes out, I'll reject it. Y'all can get some new paperwork, renegotiate what you want to.
Based on that detainer, would the court be willing to accept it?
For this offense and the, like, yes, like history here, that's fine. Good morning, ma'am. I'm sorry you've been waiting so long. I didn't even realize you were here for that, and I saw you sitting out there. You need to wave me down and say, take care of my stuff. Would you please raise your hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, ma'am.
Thank you. And sir, are you Eddie Garcia Aragon?
Yes.
And Mr. Aragon was previously in court, entered a plea of guilty to burglary of a building. I've received the pre-sentence report, and part of that report has given me the information that Mr. Garcia Aragon is not here in the United States legally, and that there is a current hold for immigration on him. And because of that, I'm not going to accept the plea agreement for probation. So at this time, I'm going to reject that plea agreement. I'm going to hold the case for a few minutes. You guys can go back and visit and see if there's something you want to work out different this morning. We can get it taken care of while Ms. Burge is here, if possible. Okay. And then Desrin Roberts, Mr. Lewis. You good over there? I feel like it should be later than 10:30.
I know, I looked up, like it's.
Like, I feel like we've been here for a long time. Good morning, sir. Are you Desrin Roberts?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Roberts, in cause number 241821, you're charged with the state jail felony offense of possession of marijuana from December 4th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that question. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Roberts is not competent?
No, Judge.
And is there any history?
There's misdemeanor history, Your Honor. There's no felonies, although there is one pending testing that looks like it'll end up as a second-degree possession of methamphetamine. Testing's not yet been completed, so no case has been brought to our office.
Okay.
I'm just looking at his record, and I don't know any other circumstances of the case other than it shows a likely second-degree possession. I would assume that'll end up as a probation concur with this, but I don't have anything else.
All right. So I think what I'll do, just to make sure we have that all lined out and possibly give them time to get that done, is I'll get a PSI, but I'll do something on the bond.
It was an April arrest, and on the lab portal, it just says testing pending.
Okay.
Doesn't have anything done yet.
All right. So, I'm going to, where did I stop when I started asking about that? Too many words today. Did I already tender number 1? Did we already do that? Okay. So what I'm going to do, Mr. Roberts, is based on your plea agreement, I'm going to reduce your bond in your case to $1,000. I'm going to make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail, but there's some very important things about that, all right? So the first thing is that as soon as you're released from, it's a big smile going on, that's good. Hopefully you'll stay smiling, you'll do everything you're supposed to, and how old are you? 26.
27 next week.
Okay, so you're going to change your ways, right?
Yes, ma'am, I have to.
All right, so yes, you need to then, for sure, for yourself and for them. So the first thing you do when you're released from custody is go to the probation department, because they're going to do a pre-sentence report. You've got to do an interview with them, and if you don't go do that, then when you come back, you run the risk of me raising your bond, going back to jail, and me not accepting this agreement. You understand?
Yes.
Also, if you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting this agreement. The last thing is I am going to require, as a condition of your bond, that you wear a drug patch. All right, you have 24 hours from the time you're released to get that drug patch on. And then you need to get proof of that to Mr. Lewis. Since I don't have a bondsman, I'm going to have Mr. Lewis get that information and then get it to us so that we know where he has it, and we can contact them and they can send us the results. So a drug patch is going to be on your arm. You go every 2 weeks and you get it changed. If it tests positive and it shows me you're using drugs, obviously we're in a whole different situation. Okay?
Judge, Mr. Roberts turned down an option that would probably get him out in the next few weeks. And I think the idea was to prevent himself from becoming a felon.
Good.
And so with that in mind, I think I'm hopeful that he is committed to straighten his life out.
That's good to know, because sometimes people will just take a short amount of time to get things over with.
I wanted the probation in order to keep myself clean.
Yeah, keep yourself clean and keep a felony conviction off your record. Now, obviously, there's another case that's out there, it looks like, from some time ago. Once that's filed, there probably will be a warrant. You'll have to go turn yourself in. We'll get it sounds like another probation that'll run with this one, but you're going to have to go through that process. As long as you're doing everything right while you're on this probation until that comes, right? Okay, we'll see you back at sentencing. Yeah, and Mr. Lewis, if you want to go maybe work on Mr. Garcia while Ms. Burge is still here, and I'll hold your other ones. And who'd you want to? Yes.
So, I think I have a.
Let's go back to Michigan and Judge Mom, and we'll probably finish our day with her unless something else comes up.
Okay, this doesn't tell me you have an appointment today, this just tells me that you called and
I know.
Monday through Friday, 9 to 4:30 AM.
Right.
PM.
Yeah, I set my appointment up last week because it took them a week to contact me because they had phone issues. And I had my first session today at 3:30.
Okay, do you have any confirmation of that?
I do not. I said I spoke to her on the phone.
Who'd you speak to?
I don't know her name, Your Honor.
If you were to test right now, sir, what is in your system?
Nothing, Your Honor.
Well, what's going on? Why, you used cocaine twice, shortly after sentencing, sir?
I know there was poor judgment. It was, to me, it was my last hurrah for it.
Your last hurrah, what does that mean?
Not to, I'm not gonna be doing it again.
So you decided you're going to violate probation and just,
Well, I was playing roulette. And like I said, my poor judgment.
so, sir, here's the thing, right? Cocaine was your drug of choice for the offense, and now you tested positive for it twice. Twice within a month of being sentenced. And you're claiming that you have an appointment today.
I do.
So here's what the court's going to do. The court's going to actually, counsel, can you be here via Zoom tomorrow for just Mr. Arriaga's, matter?
One moment, Your Honor. Let me check my schedule. What time, Judge?
What time works for you?
Would 11 o'clock work okay?
You can do that. Does that work for you, sir?
I just got take my break at work at that time. I'll
Okay.
let them know.
All right, because what I'm going to do is I'm going to confirm that Mr. Arriaga has in fact started his outpatient treatment, and you need to bring that documentation with you tomorrow, sir.
Okay.
If you do not bring it with you, you might want to let your work know that you're not returning after your break.
Okay.
Got it?
Yep.
So we'll do that at 11 a.m. tomorrow. Okay, we'll see you tomorrow.
Okay. Thank you, Your Honor.
All right, thank you. All right. All right, and then we are on the record in the matter of, let's see here. Andrew Fisk, 241432.
Good afternoon, Your Honor. Attorney Lee. Plea 84377 on behalf of Mr. Fisk. I think he just got disconnected from the Zoom on the last few seconds.
Okay. I don't see him in the waiting room. Okay, and we'll recall this matter then. Okay. All right, and then we are on the record in the matter of Aiden Pierce, 241373. Oops, I'm sorry, we're recalling the matter of Mr. Fisk. He's in the waiting room, so let's just do that right now. All right,
Hello, I'm sorry, I hit the wrong button.
that's okay. And so, as to the, Mr. Fisk,
Yes,
all right, you're not laying down, are you?
I'm sorry, I couldn't hear you.
Well, it's kind of dark where you're at. You're not laying down, are you?
No, I'm in my room. I'm just in the corner. I can open a window right on the side.
Okay. All right, and so counsel, if you could please, you indicated attorney Lee, but I need you to place your first name on the record as well, counsel.
Yes, Attorney Amber Lee, P84377.
All right, thank you. And Mr. Fisk, your name for the record, please.
Andrew Fisk.
All right, and so today's date scheduled for the adjourned probation violation as it relates to your client's allegation. He tested, the allegation your client tested positive for alcohol April 16th, failed to appear for drug testing March 10th, and arrested for drug OWI in River Rouge on March 28th. And so the last time on May 13th, we adjourned it to June 10th because the 25th district court had not yet set a date for the matter in the 25th district court. Then on June 10th, Mr. Mamet's office was retained, and the court adjourned it 2 weeks to turn defendant to file or attorney to file appearance. So counsel, what's happening today?
Your Honor, he still has, the officer hasn't done the swear to for the 25th district drunk driving case. So that has not yet been charged. We're just waiting for, I guess, when the officer does the swear to. I'm not sure if it's possible to adjourn this until that matter is resolved.
No, counsel, I'm not going to continue to adjourn this matter for that case.
And he
proceed to process through. Because
right.
The probation order doesn't indicate it has to be a conviction of another matter. And I also understand that your client has Fifth Amendment rights that you need to preserve. So for those purposes, there doesn't have to be an acknowledgement of anything as far as that goes. But if your client's intending on resolving this matter, the probation violation, because he was arrested and perhaps consumed alcohol in violation of the probation order, doesn't have to indicate how much or anything of that nature, we could proceed that way. But
yes, Your Honor, he would be admitting that he did consume alcohol, and have that missed test. In terms of the OWI, I don't know that there's anything that he could admit to other than to state that he was arrested for an OWI that has not yet been charged.
Right, okay. All right, Mr. Fisk, please raise your right hand. You solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes.
All right, and you, sir, you heard the allegations that were placed on the record, correct?
Yes.
As to those allegations, sir, that you failed to appear for drug testing on March 10th, you tested positive for alcohol April 16th, and you were arrested for operating while intoxicated in River Rouge on March 28th. How do you plead?
Guilty?
And you've gone over your advice and rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those probation violation hearing rights?
Yes.
You also understand the possible penalty as a result of your plea?
Yes.
And the recommendation in this matter is for probation to be revoked close the case without improvement, $50 probation violation fee, serve 90 days jail, tethered to treatment. You understand that's the recommendation?
Yes.
Knowing all that, sir, do you want to continue with your plea?
Continue with it.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and counsel, if you can please voir dire your client.
Did you consume alcohol in violation of your probation?
Yes.
And I apologize, Your Honor, I don't have the date of the missed test. I don't know if you need that for the
June 10th.
actual.
March 10th.
Did you have a
Oh,
missed test on March 10th in violation of your probation? And when I say missed test, I mean for alcohol and or drugs.
yes. I missed that day.
And then after you were put on probation, were you subsequently arrested for a operating while intoxicated?
Yes.
Okay, I think that's satisfactory, Your Honor.
All right, sir, and you're on probation in the 27th District Court, correct?
Yes, currently.
All right. You also, sir, as a condition of your probation conditions are not to possess or consume any alcohol or drugs unless prescribed. Is that also correct?
Yes.
And you also are to appear for random testing as called, correct?
Yes.
All right. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violations 1 and 2 will enter based upon the positive alcohol on April 16th and the failing to appear for drug testing on March 10th. The arrested for operating while intoxicated and rouge is not a technical violation. It's a non-technical violation. And counsel adds to the recommendation.
Your Honor, I would request, that he not be sent to jail. That way he can, continue to try to maintain sobriety and work through the issues that he's having. I think treatment would likely be a good option for him. Maybe a outpatient or inpatient program, because there seems to be a alcohol dependency issue going on based upon the violation and the new arrest. He hasn't been charged yet with the drunk driving. I do understand that even the arrest is not favorable to him, but that has not yet been charged, and there's no conviction for that. So we would be requesting that he be able to continue his probation, and if there are any new violations, perhaps jail would be necessary at that point.
Mr. Fisk, if you were to test right now, what is in your system?
Nothing.
Are you currently working?
Yes.
And where are you working?
McDonald's, 1469 4th Street.
And when's the last time you consumed any alcohol?
The last violation. Probably like 3 days before it. I don't know. The one right when it tested positive.
All right, and you've continued to test, correct?
Yes.
And what is your current treatment that you're participating in, sir?
AA programs, and then the mental health through team wellness.
Okay. Counsel, is your client interested in treatment court?
Possibly that's something I would have to discuss with him in terms of if he can make all of the requirements. I'm not sure if he has a vehicle, because I think those are all in person, correct, Your Honor?
It depends on which treatment court.
Okay.
So let's do this. Let's schedule this for sentencing on this matter, July 22nd. Can you do 11:15 a.m., counsel?
Yes, Your Honor, that should work.
Okay. In the meantime, you can communicate with the treatment court here. It's a mental health treatment court, or well, probably here. So to determine whether or not your client is eligible or if he's able to participate. I know that there's a time frame that we have to take into consideration. However, there is the other matter that would likely, if that's resolved by way of a plea, then he can be referred over here to continue with what he's already doing. So he can be referred on that case. So that's why I asked if your client's interested.
Yes, Your Honor, and that's definitely something we would be discussing with him, especially if that other case does get charged.
Okay, so I'm going to adjourn this to July 22nd, 11:15. So you need to communicate in with our probation department. Actually, I'm going to have you communicate with Courtney because she's with our treatment court program. She's sometimes over in the probation area. So you need to make sure you're emailing into her, okay, sir?
Okay.
And you need to make sure you're contacting in by 2 o'clock today.
Okay.
All right, thank you.
Thank you.
Thank you, Your Honor.
All right, you're welcome.
And that, as they say, will be that for today. I hope you all had fun. We got to do some fun stuff in the chat. Little more of a mild day in court, but you never know what you're going to get. You know, tomorrow we may have a dozen axe murderers for all we know. It's something different every day, but that's what makes it fun. So today we did TV shows. Thank you, Ashley, wherever you are, for getting us started on that. And it just dawned on me that perhaps when she said that her rice came out perfectly, that might have been some kind of coded cry for help. So once the show's done, you guys can kind of work on decoding that. And Ashley, if you hear us, if you're out there and you do need help, just do whatever you can to reach out, and we'll do what we can for you. So I thus proclaim it that tomorrow... Oh, Ashley is alive. Great. I hope your rice was good. So I thus proclaim it that tomorrow we'll do music. So bring your obscure music references, and we can discuss that in the chat. And then on Thursday, let's do movies. What do you say? Because if it is going to be a slower court week, it's good to have some other things to talk about as well. So we'll do that. But I'll see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. If you're not a channel member, you should be one. Go to the pinned chat. You'll find a link to do it. It's a whopping $2.99 a month, but we have lots of fun, especially on the pre-show, where this morning we got to listen to our friend Ashley and her concert. So we do a lot of fun things there. But again, I'll see you tomorrow. In the meantime, have yourselves a great first day of July. I still can't believe it's the 1st of July, but such is life. Take care. God bless.